employment. My client did advise me that while he was absconding, he did start employment at the Marina, and I confirm that's the actual name of it, is the Marina in Grand Haven. He started there, I believe, May 30th, if I recall correctly. He hopes to return to that employment, and he makes $26 an hour at that employment.
All right, thank you.
The guidelines are, as the court is aware, 5 to 23 months. The defendant did plead guilty to possession of methamphetamine, as well as resisting a call from defendant's wife or former wife. Had called, law enforcement had responded, and then ultimately encountered the defendant's vehicle. He did plea. And ultimately, he was found with a glass smoking device with residue. There was a scale, and defendant did acknowledge just smoking methamphetamine recently. The people did have a kilogram agreement to a year cap. We believe that was appropriate. We still believe that if the court were to order a sentence of 365 days, which we would support and recommend, that would encompass some of the violations or the violations involving defendant being AWOL for a period of time. So we would request the court consider following the Kilbrew agreement, ordering 365-day sentence.
Thank you. Mr. Aldridge, is there anything you wish to say before the court issues a sentence?
Yeah, I know I did abscond, and I know I should have been here. I should have had better communication. It was just one thing right after another. Life just happened. A lot of things happened.
Mm-hmm.
And this last year, so much has happened. A super toxic relationship, which actually led to these charges. My daughter ended up in DeVos. She got one more surgery, waiting for a donor right now. She needs lung. We gotta have her lung. And that's where I was. I wasn't running to run from cops or run from the sentence or run from you, Judge. I was running just to be with my daughter where she needed me.
Okay.
And then while I was there at DeVos, I was offered a job in Grand Haven, and we were on our way to the Postcard Festival when I got pulled over, and I'm here today.
All right. So
buckle up, guys. Today we're watching a sentencing hearing that quickly becomes far more serious than a routine court appearance. The defense begins by explaining why the defendant disappeared, pointing to employment and his daughter's medical situation. He insists he was trying to be there for her, not simply avoiding the court. But that explanation is about to face a much tougher test when the judge takes over and starts questioning his choices.
if you're able to go to Coast Guard festivals, you're able to see that the court allowed a bond issue back in March based upon issues involving your daughter in Grand Rapids, and then you're able to get a job elsewhere over in Grand Haven, and it wasn't you could have communicated better. You could have communicated, period. Right? So, yeah, I know. Now, all right, so here we go. The court here is absolutely appalled by your conduct. Let me take a look here at your criminal history. As a juvenile, began in 1996, 46 years of age, and you should know better. You've got quite a little history here. Some of these entries involve dismissals. So you had a B&E as a juvenile. 2 months later, you pick up a retail fraud as an adult. You were on bond for that retail fraud, picked up a second retail fraud, and while on bond, you picked up a series of other cases that apparently were dismissed. However, then we jump to 1999, and I see that you were violating probation because you look like you got probation for delivery of marijuana in the middle of all this. So while you had several cases pending, it looks like they were all dismissed as part of you pleading guilty to a delivery of manufacture of marijuana. All right, so then 1999, while on probation, you get a minor offense, expired license. Okay, but then that's followed up immediately with a driver license suspended. So you've been on, you got picked up for no license, and then you got picked up also for driver license suspended. So you can't seem to file orders, and you're going to be deceptive. Then, while on probation again, just all within 1999, you pick up some more crimes of dishonesty, yet another property crime involving a breaking and entering, plus you had a concealed weapon. And that's where you get your first prison sentence. Well, also 1999, I had 2 beatings. So you got two different B&E cases, and each got you a prison sentence. 2019, unregistered vehicle, not a big deal, but this just means that as long as you think no one's paying attention, you're going to try to get away with stuff. Looks like you had a couple warrants out there for failing to appear in the file. 2021, you pick up, again, driving license suspended, not a big deal, but that tells me that when you think when no one's watching, you're going to do what you want. In fact, in 2021, you picked up yet another one of those, but again, that one was dismissed. Looks like it's part of the plea agreement and some other files. 2022, back to violating property crimes, and you get a 4th degree arson, and that one was in front of me. You got 18 months of probation, and you had violations. In fact, violations of the same nature. You had meth and driving license suspended. 2023. Now we're here for possession of methamphetamine. And let's see, now we jump down to 2026.
The judge now begins challenging the defendant's explanation, pointing out that he managed to travel, attend events, and even secure employment while failing to communicate with the court. From there, the judge examines his criminal history and finds a pattern stretching back years, involving theft-related offenses, probation violations, drug charges, license problems, and prior prison sentences. What initially sounded like one isolated mistake is now being presented as a repeated pattern of ignoring consequences.
Earlier this year. Now here's what's really important. This offense date for the domestic violence occurred on January 28th. Now, it was largely skipped over when everybody talked about the PSI, and that's okay. Underneath the description of the offense here, this offense occurred on February 11th. And it was in regard to your ex-wife calling because you were in violation of a PPO. Now, I'm the one that gave that personal protection order. So what I'm seeing here is repetitive issues with you complying with my orders. And on January 28th, I entertained over in Wexford County a petition for a personal protection order ex parte by Christina against you. And in there, she talked about you getting into a vehicle, assaulting her, punching her, and if I remember correctly, she was pretty bruised up. So I issued that on the 28th after she got this, after the assault that occurred here in this one file. And that means within days, you were violating the personal protection order that led to the police responding here. Now, you could have been charged with violating the personal protection order. You could have been charged with contempt. You could have been charged with further stalking. The guidelines are inadequate because they're not fully grasping this.
The hearing takes an even more serious turn when the judge focuses on the protection order. The court explains that the order followed allegations involving the defendant's ex-wife, including stalking and an assault that reportedly left her bruised. More importantly, the judge says the order was allegedly violated only days after it was issued. From the court's perspective, this is no longer just about missing court requirements. It reflects repeated disregard for judicial orders and escalating conduct.
And you get graces from the court? No. I'm not going to accept your excuses. They're not excuses. We were willing to work. I was willing to work with you before. You didn't show up for testing. And you absconded for months. You were doing it for your own good. I don't believe that you were doing it necessarily for the care of your daughter. Because when it comes to your daughter, if she has medical issues, then I have sympathy for her. But I definitely don't think you were doing a good job. You're an abusive person, stalking, breaking and entering, property crimes, drug life, drug history. No. When I hear stories like this, I think I'm doing a better job for your child than you are. Because you are not going to go spend time with her. At least not right now. And you've been dealing with methamphetamine now for 15 years, 16 years. Maybe starting marijuana 30 years ago at the age of 16 was not a good idea. Because why? Because that impacts you, impacts your brain development. And at that age, And that's probably why you've been on this long history. I'm not trying to punish you for that necessarily, but I look at this and I say, I've got a defendant who's got repetitive acts and crimes of dishonesty, thwarting any authority, driving when he doesn't have a license, doing whatever he wants, disregarding orders of me and of a court. Don't go near this person. And you did. Within 2 weeks of me giving you the first PPO. It says here you may not have been aware of it, but I'm going to tell you, I issued it. I don't know if my file here includes a copy of the proof of service, but the fact is I ordered one, and you're a danger to people. It may be a toxic relationship, but it appears to be that you are an equal part of the toxicity, and you're using drugs, and you will not obey this court's orders. I don't care. I was willing to work with you the first time. I'm not now.
At this point, the judge completely rejects the defendant's attempts to justify his actions. The court acknowledges sympathy for the daughter's situation, but says that does not excuse the defendant's behavior. The judge points to years of drug involvement, dishonesty, violations, and repeated failures to follow court orders. Then comes a critical moment. The judge makes it clear that there is virtually no doubt the defendant will receive a prison sentence that day.
You're going to have a chance to withdraw your plea in a minute, because there's absolutely zero doubt in my mind you're going to get a prison sentence for me today. You violate bond, you violate probation, you do what you want, and you commit crimes of dishonesty and drug crimes, and you disappear, and you think that there are good excuses. Well, if you go out and get a job, you can call this office for community corrections and report on your bond. If you can't, that's your choice. This court sentences the defendant to a $68 state minimum fee for each one of the... And then you resist the law enforcement officers. They're just trying to do their job. Oh my gosh. While you're there, violating a personal protection order. And based upon the entire history of this case that I've covered quite well, seeing that bond doesn't work, probation doesn't work, jail doesn't work, even prison hasn't worked, the sentence is definitely reasonable, proportionate, that I'm going to sentence the defendant to a prison term of 20 to 120 months for count 1. As to count 2, this court finds reasonable grounds based upon all those factors discussed to exceed an intermediate sanction cell, and again, the court sentences the defendant to a prison term. 1 second. That is 16 to 24 months. That is the statutory maximum. It is within the guideline range, even though the guideline range is an intermediate sanction cell. The court again finds there to be reasonable grounds to give a jail sentence and even to give a prison sentence, which is even allowed within the statutes that cover intermediate sanction cells, because I have found reasonable grounds and because I find the sentence to be reasonable and proportionate. The defendant has the right to withdraw his plea based upon the Killebrew Agreement. Bertel, what does your client wish to do?
Ma'am, just speak moment, Your Honor.
Sure.
My client would not wish to pull his plea, Your Honor.
All right, thank you. So I have talked a bit sternly today. That's because I needed to change the tone and tenor of the courtroom. This acceptance of, hey, I'm doing this because I had good reasons. I had to talk that way to say, no, you didn't. You're a father. Do you want to be there? Stop committing crime. Good luck. We're adjourned.
The final section delivers a consequence everyone has been waiting for. The judge explains that bond, probation, jail, and even previous prison intervention have failed to change the defendant's behavior. The court then imposes prison terms of 20 to 120 months on one count and 16 to 24 months on another. After giving him a chance to withdraw his plea, the judge closes with a direct message about responsibility and fatherhood. If you found this case interesting, make sure to like the video, subscribe to the channel, and we'll see you in the next video.